Hey guys, welcome to a new video. And here's a question that we'll answer. I was sued and have a judgment against me, but I was never served. What are the steps to take to get rid of the judgment? Now, we get this probably once every quarter or so, maybe every 2 months. Somebody will contact us, and it very rarely is a judgment from a month ago or 6 months ago. These are judgments from 2005, 2008, 1999. I mean, these are really, really old judgments. And people didn't know about them. And all of a sudden, they get a call, they get a letter, or they get a garnishment. And they're like, what is going on? And they realize, oh, there's a lawsuit filed 10, 15, 20 years ago. And there's a judgment from, 10, 15, maybe 19 years ago. And the reason I don't say 20 is at the end of 20 years in Alabama, judgment is considered paid. And so they're not going to be collecting it after that. But, it could be 19 years ago or however long ago it was. And so here's the process that I go through. And now other lawyers may do it differently. If you're in a state other than Alabama, it may not be the same. But hopefully this gives you kind of a framework to at least think about how do you attack a judgment when the claim is that I was not served. So first you gather the facts about the judgment. That's pretty easy. Get a copy of the judgment. So what day was the judgment entered? What's the amount? Who's suing you? That type of thing. And then you want to find out about the service. So how do they say that you were served? Do they say that they personally handed it to you? Or they gave it to an adult living in your house? Or they sent it to you by certified mail? How do they claim that they provided service to you? And you want to get as much detail as you can. So if it's personal service, hopefully the process server who supposedly handed you the paper, will put on there the date. Sometimes they'll put the time. Sometimes they'll put the exact location. Now other times it's sort of vague. They'll say, on September 1st, 2006, I served Joe Blow in Jefferson County, Alabama. Well, that's not very specific, but you work with what you got. Other times it's very specific. It was at 10:23 a.m. It was at 123 Main Street, and they give a description of who you are supposedly, and that's very helpful because we've had people that the description says, 5'9", black woman, 140 pounds. And my client goes, I'm barely 5 foot. I'm 220. I'm white, and I'm 60 years old. It said the person they served was 30. That's pretty good. So as much detail as you can find out about. Now, if they say they left it with somebody at your house, do they give a name? Do they say I left it with Emily or Bobby or Susie or Jerome or whoever it was? And then if it's certified mail, there should be a copy of the green card. So you can see, well, who signed for that? Now, the next step after you gather all those facts is to make sure that you, when I say you, I mean either you specifically or your attorney, understand the rules on service. Now, typically that's Rule 4 under the Rules of Civil Procedure. So if we're talking about federal court, it's Rule 4. Alabama Rules of Civil Procedure, it's 4. A lot of states have similar numbering on rules, but yours may be different. So figure out where your rules of civil procedure talk about how you serve somebody. So in general, this is true in Alabama, and I think in most states, but obviously you've got to check the rules yourself. So you can be personally served anywhere. In law school, we have cases where somebody was served while in an airplane. Here at 35,000 feet, somebody says, hey, are you John Watts? Well, yes, I am. Hey, you've just been served. I would think it makes for an awkward rest of the flight. But anyway, you can be served anywhere. Now, if they say they gave it to somebody at your house, well, normally it has to be an adult who lives there, not a visitor, not, the guy cutting your grass or the UPS man who happens to be there and they just hand it to him. It's got to be somebody that actually lives there. And then for certified mail, it has to be actually you, okay, or your agent. Now, typically, an agent is more in the context of a corporation. Okay, so we sue XYZ company, and we serve their agent. Okay, but if maybe you've been out of the country and you authorized your spouse or your adult child to accept, mail for you, then that might qualify. But anyway, you've got to understand the rules of service. And then step number 3 is you look at those rules and look at the facts and say, do these match up? So if they say, I personally served you on this date, well, that would be valid under the rules. Okay. And the next step will be you look at the evidence to see if you can disprove that. But if they say they left it with somebody in your house and you're like, I've lived alone for the last 20 years. They obviously didn't leave it with somebody who lives in my house. Because a lot of times what these process servers will do is they'll actually give it to your neighbor. They'll see somebody walking their dog in the neighborhood and they'll say, hey, do you know John Watts who lives over there? Oh, yeah, I know him. They hand them the paper and run off. And then they say, oh, I served it. Somebody lived there. No, they gave it to a neighbor. It's certified mail. It may be somebody else in your house signs for it. Well, typically that's not going to be valid service under Rule 4. So then this 4th step is you look at the evidence. So if they say, I served you in Jefferson County in September 1st, 2005. Okay. Well, if that's all the detail, then you need to eliminate the possibility that you could have been served in Jefferson County on September 1st, 2005. So were you out of the country? Were you out of the state? Were you in Montgomery, Alabama, or Mobile, Alabama, or Huntsville, Alabama, or Atlanta, Georgia? Can you get some proof of that? Do you have a credit card that shows receipts? Do you have, maybe you stay at a certain hotel, or you had plane tickets, or you were at a conference, or, and we've had this, you were in ICU. Kind of hard to be served when you're in ICU at the hospital. So what evidence can you gather? Now again, if it's, they say they left it with somebody who lived with you, can you prove that person didn't live with you? Or maybe nobody lived with you. So again, get proof of that. Or they say, I served you at 123 Main Street, and you realize 2 years before you were supposedly served there, you moved. You moved 100 miles away. Well, what's the proof of that? Well, here's my closing documents where I sold my house, or where I terminated the lease, or where I started the new lease 100 miles away, or bought a new house 100 miles away. Where's the proof of that? And same thing with certified mail. Get the green card. Who does it say? Is that your name on there? Is that your signature on there? And so once you gather the evidence and you understand the law, then you file what's called a motion to set aside the judgment as being void for lack of service. And so you tell the judge, here's the law. And I can tell you in Alabama, I think the law is very clear that if you're not served, the judgment's void. Now, I can't speak to any other state, but I would imagine every other state's the same way, because if you're not served, you have no opportunity to defend yourself. So it'd be kind of weird for a court to say, well, even though you weren't served, that judgment stands. Now, it's very important to distinguish between what I'm talking about and setting aside a default judgment when you were served. So if you were served and you did not answer and a default judgment happens, the rules, then we're typically looking at, I guess it'd be Rule 50, where it tells us what's your time limit if you were served and there's a default judgment, to ask the court to undo that default judgment. Now, that default judgment's valid. You're just saying, hey, judge, I made a mistake. It was excusable neglect. I've got valid defenses or certain criteria you have to lay out. I'm asking you to help me out here. What we're talking about in this video is not where you're asking the court to kind of give you a break. You're just saying, look, find that I was never served, because if I was never served, there can be no judgment. If there's no judgment, there can be no garnishment, no lien put on my house, no sheriff's sale at my house. Nothing flows from the case as far as collection activity if there's no judgment. So you file a motion to set aside the judgment. We always file an answer. Now, when we do that electronically, it'll say, warning, this case closed. I'm like, yeah, I know it's closed. I still want to file the answer. Well, why do we do that? Because I want the judge to know that we're not playing games. See, here's what some people do. And they think they're being clever, and I really think they're just begging the judge to rule against them. It's like the worst psychology in the world, where they say, hey, judge, I was never served, and I want you to set aside the judgment. Then I want you to make the other side serve me. And I'm going to try and, escape the service here, avoid the service. And then once they serve me, then I'll file an answer. Well, it should not matter to the judge, but think about it just from a psychological standpoint. Judge is going to say, how annoying. I mean, there's a lawsuit. You're here, you're filing a motion, you've got a lawyer or however you're doing it. Why don't we just get on with the case? So that's why we filed the answer to say we desperately want a trial. We want to clear our name. And to show how serious we are, we file an answer. And in the answer, we don't raise anything about, hey, I wasn't served properly. Okay, and that is a defense when you file an answer, but we don't raise it because we want to tell the judge, look, preferably we have a trial today. And obviously I'm exaggerating when I say this, but if we can't do it today, how about tomorrow? Well, how about the next day? In other words, we're not saying we want to drag this thing out because the judge is going, oh my goodness, I got to open this case from 2005 or 2010 back up. It's going to look bad in my reporting. And is the defendant going to want to drag this thing out? We're like, no, we want an immediate trial. And so it lets the other side know that you're very serious about this. I had a video, I think a couple years ago, about why do we file an answer even before we're served? Okay, now this is not in the context of default judgment. And I think I used the illustration of the story of David and Goliath. So, here's massive Goliath and, all this armor and weaponry. And here's David. And, if I was David, I would have stayed as far away as possible. But if you read the Bible, it says David ran towards him. And you got to think for a moment, Goliath's going, wait a minute. This is just not right here. What is going on? He should be running away from me, not towards me. Well, that's what we do in these debt buyer cases is we're not trying to delay trial. We're trying to get to trial. And that has an effect on the other side where they go, why is the defendant so eager to get to trial? Okay, because we want to get to trial. We want to win the case. That totally clears our name. And then we look at, well, what type of lawsuit can we file against the debt buyer? Okay. So that's the strategy that we use with this. Now, obviously, if you're a client of ours, we'll talk to you individually. If you're not a client of ours, you use your own judgment, do your own research, your own due diligence on this. But I want to give you a framework to at least think about this. Is you gather those facts, you make sure you know the law, and then you kind of lay those on top of each other. Well, how do the facts and the law go together? And was I properly served? Now, if you're properly served, you can't attack the judgment. You cannot attack the judgment. You've got to look at, can you settle it or file bankruptcy or something else? But if you can show that you were not served, at least in Alabama, I think everywhere else, but at least in Alabama, if there was not proper service, you didn't know about the lawsuit, the judgment's void. And then you gather that evidence, okay? Every piece of evidence that you can find. So you may know, wait a minute, I was out of the country. Okay, that was bad service. But then get the proof. Get the plane tickets, get the hotel bills, get the conference you were at, get the hospital records, whatever it is. File a motion to set aside the judgment. We file an answer at the same time just to show the court that we're serious and we really want to go to trial. So I hope that that's helpful to you. And if you have any comments or questions of a general nature, put those below. If you have a specific question and you're not in Alabama, or I should say not dealing with a judgment in Alabama, you've really got to talk to a lawyer in your own state. I just don't know what the rules of civil procedure are in Montana or New Hampshire, wherever. So if you're in Alabama, you can get with us 205-879-2447 or alabamaconsumer.com. And I appreciate you watching this video, and I will look forward to talking to you in the next one. Thanks, guys. Bye-bye.